Title 11 of the Revised Corporation Code addressing non-stock corporations encompasses three main chapters. Chapter 1 focuses on the members, comprising three successive sections addressing the right to vote, non-transferability of membership, and termination of membership. Chapter 2 pertains to trustees and officers, with two successive sections covering the election in terms of trustees, as well as the list of members, proxies, and the place of meetings. Finally, Chapter 3 consists of two sections, outlining the rules of distribution and the plan of distribution of assets.
Title 11 Non-Stock Corporation. Section 86 states the definition of a non-stock corporation. A non-stock corporation does not distribute dividends to its executives, trustees, or members from any portion of its income. It shall, whenever necessary, use any profit it may make as a byproduct of its operations to further the objective or purposes for which it was founded. A non-stock corporation is not defined by Section 86 as one that does not have capital stock that is divided into shares. It simply states that an organization that does not distribute its money to its officials, trustees, or members is referred to as a non-stock corporation. Therefore, a company will be more of a non-stock than a stock corporation if it possesses capital stock but is not permitted to pay dividends to its officers, trustees, or members. Section 87 states the purposes of a non-stock corporation. A non-stock corporation may be organized for any or a combination of the following purposes: charitable, religious, educational, professional, cultural, fraternal, literary, scientific, social, civic service, similar purposes like trade, industry, agriculture, and like chambers or a combination thereof. It should be highlighted that a non-stock corporation does not exist for profit, as stated in the aforementioned purposes. However, that does not mean it can't make a profit. Profits that arise naturally from a non-stock corporation's operations may be retained for the corporation's goals rather than being paid out as dividends.
Chapter 1, titled Members, comprises three consecutive sections, namely Section 88, addressing the right to vote, Section 89, discussing the non-transferability of membership, and Section 90, covering the termination of membership.
Chapter 1 Members, Section 88 Right to Vote. All members possesses the inherent right to participate in the voting process, wherein they are granted the privilege of exercising at least one vote. However, it is imperative to acknowledge that this right is subject to certain restrictions. In trustee elections, members can cast votes equal to the number of trustees to be elected, but are limited to one vote per candidate unless stated otherwise. This is applicable in cases of cumulative voting in non-stock corporations with capital stock. The members may vote in various ways, such as by proxy, face-to-face, or by remote communication. For instance, Member A has 9 votes to distribute among the candidates. They can choose to allocate these votes in various ways, such as casting one vote for each of their preferred 9 candidates or distributing the votes unevenly among the candidates, but with the constraint that no more than one vote can be given to any single candidate. This rule aims to ensure a fair and balanced distribution of votes among the candidates during the election process. Section 89 Non-Transferability of Membership. The non-transferability of memberships in non-stock corporations is typically established to maintain the specific character, identity, and purpose of the organization. The non-transferability of memberships in non-stock corporations is a deliberate choice to uphold the organization's mission, foster a sense of community, control the membership base, prevent speculation, and comply with legal and governance requirements. The benefits outlined in this agreement cannot be sold, transferred, assigned, pledged, attached, or encumbered. Section 90 Termination of Membership. Termination of membership results in the discontinuation of all membership privileges for the remainder of the current membership year, and reinstatement within the same year is not possible. Any subsequent applications for membership in the following years may be subject to probationary terms or additional requirements. Termination of membership in an organization can stem from various factors as specified in its governing documents. Common reasons for membership termination include the failure to pay annual dues for a designated period or to attend a required number of regular member meetings. Additionally, termination may occur for violations of the organization's code of conduct or ethics, criminal convictions, non-compliance with established policies, misuse of membership privileges, misrepresentation during the application process, prolonged inactivity, conflicts of interest, breaches of contractual agreements, and failure to align with the organization's mission and objectives. It is crucial for members to familiarize themselves with the terms and conditions outlined in the organization's bylaws or governing documents to understand the specific grounds for membership terminations. Otherwise, this clause results in fully losing rights in the corporation and its properties.
Chapter 2, titled Trustees and Officers, expounds upon the procedures concerning the election and tenure of trustees. Additionally, it delves into matters pertaining to the compilation of a list comprising members, proxies, and the designated venue for meetings.
Chapter 2, Trustees and Officers. Section 91, Election and Term of Trustees. Based on this section, the number of trustees may or may not be more than 15 depending on the articles of the incorporation and the bylaws. The trustees so elected shall have a term of not more than 3 years until successors are elected and qualified. In terms of the independent trustees who are not a member of the non-stock corporation, they can only be elected if and only if the corporation is vested with public interest. Section 92, List of Members and Proxies, Place of Meetings. A non-stock corporation shall at all times keep a list of its members and their proxies in the form that the SEC may require. The list shall be updated to reflect the members and proxies of record 20 days prior to any scheduled election. Place of meetings shall be any place within the Philippines with proper notice which is sent to all members indicating the date, time, and place of the meeting.
Lastly, Chapter 3, denominated Distribution of Assets in Non-Stock Corporation, encompasses two distinct sections elucidating the principles governing asset distribution and the blueprint for the allocation of assets.
Chapter 3, Distribution of Assets in Non-Stock Corporations. Section 93 is about the rules of distribution. The order of payment and distribution of assets upon dissolution of a non-stock corporations are the following. Number 1, liabilities and obligations. Number 2, assets held subject to a condition that requires the return, transfer, or conveyance. A condition that arises from the dissolution of the entity must be transferred or conveyed in line with such requirements. Number 3, assets held subject to restrictions allowing their use only for educational, charitable, religious, or similar purposes may be transferred or conveyed to one or more corporations with a similar purpose. Number 4, assets specified in the Articles of Incorporation or bylaws for distribution to members in line with their distributive rights. Number 5, assets to be distributed in accordance with a plan of distribution to such persons, societies, organizations, or corporations whether or not organized for profit. For the distribution to members, as provided in Section 86 of a non-stock corporation's income, is only to be used to achieve its purposes rather than being given as dividends to its members. On the other hand, in the event of dissolution, its members may get their distributive rights as outlined in the bylaws or the Articles of Incorporation. The members are not entitled to any earnings made by a non-stock corporation as a result of its operations. And for the distribution to persons organized for profit, it may be noted that the plan of distribution may include distribution to persons or entities organized for profit. Section 94 is about the plan of distribution of assets. The procedure in the adoption of a plan of distribution of assets of a non-stock corporations are the following. Number 1, adoption by the Board of Trustees by majority vote of a resolution recommending a plan of distribution and directing its submissions to a vote at a regular or special meeting of members having voting rights. Number 2, Written notice shall be given to each member entitled to vote, setting forth the proposed plan of distribution or a summary thereof and the date, time, and place of meeting. Number 3. Approval of at least two-thirds of the members having voting rights of the plan of distribution.
Title 12 of the Revised Corporation Code addressing closed corporations encompasses 10 sections. These sections cover various aspects, including the definition and applicability of the title, articles of incorporation, the validity of restrictions on the transfer of shares, the consequences of issuing or transferring stock in violation of qualifying conditions, agreements among stockholders, situations where a board meeting is unnecessary or improperly conducted, the preemptive right in closed corporations, the amendment of articles in closed corporations, handling deadlocks, and the withdrawal of a stockholder or the dissolution of the corporation.
Title 12 Closed Corporations. Section 95 Definition and Applicability of Title. A closed corporation is one whose articles of incorporation provide that all the corporation's issued stock of all classes, exclusive of treasury shares, shall be held of record by not more than a specified number of persons, which is not exceed 20. All the issued stock of all classes shall be subject to one or more specified restrictions on transfer permitted by the title on closed corporations in the Corporation Code. And the corporation shall not list in any stock exchange or make any public offering of any of its stock of any class. Where two-thirds of the voting stock or voting rights of a corporation is owned or controlled by another corporation which does not fall within the stated definition of a closed corporation, the former shall deem not a closed corporation. Corporations which are vested with public interest are not allowed to be incorporated as a closed corporation. Examples of corporation which is vested with public interest are mining companies, oil companies, stock exchanges, banks, insurance companies, public utility, and educational institutions. Section 96 Articles of Incorporation. Stated here in section 96 is the articles of incorporation of a closed corporation. First is a classification of shares or rights, the qualifications for owning or holding the same, and restrictions on their transfers subject to the provisions of the following section. Second is a classification of directors into one or more classes, each of whom may be voted for and elected solely by a particular class of stock. Example, let's consider a company named XYZ Inc. with two classes of stock outlined in its articles of incorporation, namely A and B. The allocation of directors is specified for each class with a certain number of directors for A stock and for B stock. Holders of A stock have the exclusive right to elect the directors representing the A class, and likewise holders of B stock are solely responsible for electing the directors representing the B class. Importantly, this election process occurs independently of the number of shares held within each class. Third, greater quorum or voting requirements in meetings of stockholders or directors than those provided in this code. The Articles of Incorporation of a closed corporation may provide that the business of the corporation shall be managed by the stockholders themselves rather than by a board of directors. Then the stockholders shall be subject to all liabilities of a director. The Articles of Incorporation may also provide that all or certain specified officers or employees shall be elected or appointed directly by the stockholders. Section 97. Validity of restrictions on transfer of shares. This section imposes two conditions for the validity of restrictions on the right to transfer shares. First is restriction on transfer of shares should be indicated in the Articles of Incorporation, stock certificates, and bylaws. Otherwise, it is not binding on any purchaser in good faith. Second is the restriction shall not be more than onerous, granting the existing stockholders or the corporation the option to purchase the shares of the transferring stockholders with such reasonable terms, conditions, or period stated. Why is there a need for restriction in stock transfer? There is a need for stock transfer restriction in closed corporations to prevent changes in control of corporations and to maintain the lectus personae. Section 98. Effects of issuance or transfer of stock in breach of qualifying conditions. The qualifying conditions here is stated in the preceding section, which is the section 97. The effects are if a stock of a closed corporation is issued or transferred to any person who is not eligible to be a holder thereof under any provision of the Articles of Incorporation, and if the certificate for such stock conspicuously shows the qualifications of the person entitled to be holders of record, and if the Articles of Incorporation of a closed corporation states the number of persons which is not exceeding 20 who are entitled to be stockholders of record, and if the certificate of such stock conspicuously states such number, and the issuance of or transfer of stock to any person would cause the stock to be held by more than such number of persons, and if a stock certificate of a closed corporation conspicuously shows a restriction on transfer of the corporation's stock and the transferee acquires the stock in violation of such restriction. In the three cases mentioned, the transferee is conclusively presumed to have notice of the restriction or condition and therefore is not allowed to prove lack of notice even if such is the fact. Next is whenever a person to whom stock of a closed corporation has been issued or transferred or is conclusively presumed under this section to have notice of the person's ineligibility to be a stockholder of the corporation, or that the transfer of stock would cause the stock of the corporation to be held by more than the number of persons permitted under its Articles of Incorporation, or that the transfer violates a restriction on transfer of stock and the corporation may, at its option, refuse to register the transfer in the name of the transferee. The corporation cannot be compelled to register, although it may, at its option, register the transfer of the stock in the name of the transferee. But the transfer, however, shall be binding upon the corporation even with such conclusive presumption, where it has been consented to by all the stockholders or has amended its Articles of Incorporation of the closed corporation. The term transfer as used in this section is not limited to transfer of value. The term transfer includes donations as it is not limited to a transfer for value, so the conclusive presumption of notice applies to a donee. The breach of any restriction in the issuance or transfer of stock is without prejudice to the right of the transferee under any existing laws to rescind the transaction or recover under applicable warranty.
Section 99, Agreement by Stockholders. These provisions provide a legal framework for agreements among stockholders in a closed corporation, emphasizing the survival and enforceability of pre-incorporation agreements, the establishment of voting rights, non-partnership status, limitations on interference with board powers, and the imposition of fiduciary duties on actively engaged stockholders. Under this are the legal provisions related to agreements among stockholders in a closed corporation. Pre-incorporation agreements among all stockholders of a closed corporation remain valid and binding after incorporation. These agreements continue to be effective as long as they align with the Articles of Incorporation, except for provisions mandated by law to be included in the articles. The intent is to ensure the continuity of agreements made before the formal establishment of the corporation, as long as they do not conflict with legal requirements. A written agreement among two or more stockholders in a corporation can specify the terms for exercising their voting rights. This agreement may outline how the shares held by the stockholders will be voted, either based on agreed-upon terms or in accordance with a mutually established procedure. Provisions in a written agreement among stockholders addressing any aspect of corporate affairs will not be invalidated on the basis that they might create a partnership-like relationship among the stockholders. A written agreement among stockholders in a closed corporation will not be invalidated solely because it addresses the business conduct and affairs in a way that restricts or interferes with the discretion of the board of directors. However, such agreements impose on the involved stockholders the managerial liabilities imposed on directors by the code. Stockholders actively involved in managing a closed corporation are held to strict fiduciary duties towards each other and are personally liable for corporate torts unless the corporation has sufficient liability insurance. Section 100. When a board meeting is unnecessary or improperly held. If the bylaws don't specify otherwise, actions by directors in a closed corporation taken without a properly called meeting and notice are deemed valid in certain situations. This includes obtaining written consent from all directors, the knowledge of stockholders without objection, directors being accustomed to informal actions with stockholders agreement, or all directors having knowledge without objection. An action at a meeting without proper notice is ratified by a non-attending director unless they promptly submit a written objection after becoming aware of the action. Section 101. Preemptive right in closed corporation. In closed corporations, the preemptive right of stockholders ensures that existing shareholders have the first opportunity to purchase newly issued shares, whether for capital, property, services, or debt settlement. This right applies to all types of stock unless the articles of incorporation state otherwise. The articles can modify or exclude preemptive rights under specific conditions, allowing flexibility in attracting new investors. Imagine a company called XYZ Incorporation owned by two people, A and B. They each have half of the company. If XYZ Incorporation wants to create more shares, let's say 100, the preemptive right means A and B get the first chance to buy more shares before the others. This helps them keep their equal ownership. But if the company's rules in the articles of incorporation say something different, like not offering A and B new shares first, then the company can sell the new shares to others without asking A and B first.
Section 102 is about the amendment of articles of incorporation. The purpose of amendment are to remove or delete any provision required to be stated in the articles of incorporation in order that a corporation may be considered a closed corporation and to reduce a quorum or voting requirement stated in the article of incorporation. The vote required for validity of amendment of articles of incorporation of closed corporations are the following. Number 1, 2/3 of the outstanding capital stock voting and non-voting, or number 2, such greater proportion of shares as may be specifically provided in the articles of incorporation. The SEC, in the exercise of its power to arbitrate, may make an order. Number 1, canceling or altering any provision in the articles of incorporation, bylaws, or stockholders agreement. Number 2, canceling, altering, or enjoining any resolution or other act of the corporation or its board of directors, stockholders, or officers. Number 3, directing or prohibiting any act of the corporation, its board of directors, stockholders, officers, or other persons party to the action. Number 4, requiring the purchase at their fair value of shares of any stockholder either by the corporation, regardless of the availability of unrestricted retained earnings in its books, or by the other stockholders. Number 5, appointing a provisional director. A provisional director shall be an impartial person who is neither a stockholder nor creditor of the corporation or any of its subsidiary or affiliate. He is not a receiver of the corporation and does not have the title and powers of a custodian or receiver. He shall have all the rights and powers of a duly elected director, including the right to notice of and to vote at meetings of directors, until such time when he is removed by order of the SEC or by all the stockholders. Number 6, dissolving the corporation. And number 7, granting such other relief as the circumstances may warrant. And for the compensation of the provisional director shall be number 1, determined by the agreement between such director and the corporation, subject to the approval of the SEC. Number 2, fixed by the SEC in the absence of such an agreement between the provisional director and the corporation, or in the event of disagreement between the provisional director and the corporation. Section 104 is about the withdrawal of stockholder or dissolution of corporation. A closed corporation stockholder may for any reason require the company to buy his shares at fair market value, which cannot be less than the shares par or issued value. Therefore, the justification for this withdrawal is not restricted to the items listed in Section 80. However, before the corporation is forced to make such a purchase, it must have enough cash on hand to pay off its debts and liabilities, excluding capital stock. This serves to protect the interests of creditors who own preferential rights on the corporation asset. Any stockholder of a closed corporation has the right to force the dissolution of the company by filing a written petition with the SEC whenever may actions taken by the directors, officers, or people in charge of the company are unlawful, fraudulent, dishonest, oppressive, or unfairly prejudicial to the corporation or any of its stockholders, or when company assets are being misapplied or wasted.
That's all for non-stock and close corporations. Thank you for watching.